Hi, we are Phyllis, Benjamin and Benedict. We are the delegation for the Federal Republic of Germany. Today we are looking at the transfer and assignment rules in the German legislative system in regards to our European sales law. After having looked at the features of German property law and its characteristics, we will deal with the German position towards our neighbors from France and also with our position to the common law-based system of our British friends from the United Kingdom. As an introduction, a transfer and assignment rule encompasses the transfer of rights held by one party, the assigner, to another party, which is called the assignee. The detail of the assignment determines some additional rights, liabilities, or duties. A transfer has two requirements. It must be clear between the transferor and the transferee that the former has lost the property right and that the latter has acquired it. The next requirement is publicity, which requires that it should be known to the public at large who is the holder of a property right. In Europe, there are two main ways regarding the transfer of property rights. One is the consensual system and one is the tradition system. A consensual transfer system merely requires consensus to transfer a property right between the seller and the buyer. This means that the conclusion of the contract of sale will transfer the property right from the transferor to the transferee, or also called the acquirer. Furthermore, there is a difference made between movable and immovable objects. In the case of movable objects, the buyer becomes the owner immediately upon conclusion of the contract. When it comes to the case of immovables, the property right is also transferred, but this transfer will only have effect against the rest of the world. In a traditional system, it is merely required, besides a contract of sale, that there is a special act to transfer the property right. A contract of sale in a traditional system therefore serves as the starting point for the transaction, but in itself does not have effect in property law. The contract is known as the title for the transfer in these systems. The assignment rules are of considerable importance, as they allow owners to transfer their property for monetary gains or commercial returns. The transfer rules are of importance as they make clear that property has been transferred from one owner to the other and is also visible for everyone else. The main legal issues consist of the fact that there are different transfer systems in different countries and they lead to uncertainty when one becomes the owner of an object. Secondly, there are different claims in different countries and how those different member states should deal with it. In order to answer question 2, the position of the Federal Republic of Germany in relation to the French Republic. In Germany, paragraph 929 of the Bundesgesetzbuch requires a transfer of possession. This entails the will of the transferor to make the acquirer to be the possessor. Corresponding to that is that there is a will of the transferee to acquire possession from the transferor. Thus, possession is not only a fact, but also a right, meaning that it is a legal act. However, in practice, the transfer of possession is seen as no more than a factual act, according to paragraph 854, subsection 2 of the Bundesgesetzbuch. This indicates that in Germany, if there is a valid transfer, the transferor should be privileged to dispose. Furthermore, in order for the transfer of ownership to be valid, the acquiring party must be in good faith, and all other requirements for third-party protection need to be met. Germany's position in contrast to France is that Germany uses the traditional transfer system, which means that there is delivery needed for the ownership to pass, whereas a contract merely calls for obligation to transfer. In France, however, you become the owner at the moment of conclusion of the contract, according to the solo consensus rule, which is established under Article 1583 as well as Article 711 of the Code Civil, the French Civil Code. Furthermore, Germany uses an abstract system of transfer, meaning that the transfer is independent of the validity of the contract. In avoidance of contract, there is no proprietary effect. In itself, it aims to protect the third party. The French system, however, is a causal system of transfer, where the transfer of ownership depends on the validity of the contract, which is called valid causa traditionis. Property does not pass under a void contract, and a third-party buyer in good faith is protected, as there exists a property right to claim back the object. The position of the Federal Republic of Germany in relation to the United Kingdom. As already established, Germany's position, in contrast to the United Kingdom, is that Germany uses the traditional transfer system, meaning that there is delivery needed for the ownership to pass, whereas a contract merely calls for obligation to transfer. In contrast to that, the common law system in the United Kingdom is a mixed system, which means that when it comes to immovable property, it is governed by the delivery system. An exception is made in equity, where immovable property is handled by a consensual system. Moreover, in the UK, movables are dealt with by the consensual system, which only requires a contract for the transfer of ownership to be established. Lastly, as a German state, we understand the necessity of harmonizing the diverse national legislations that exist in the European Union in the field of private or contract law. Because by creating a common legislation on contracts, cross-border contracts will be safer and easier, strengthening the internal market. Both B2B and business-to-consumer contracts will increase, and Europe will experience economic growth, hence becoming more competitive. However, in this efforts of harmonization, we strongly propose not to abandon the general principle of good faith, which other member states, such as Ireland and our friends from the United Kingdom, deem to be undesirable arguing. They introduce elements of discretion and uncertainty that are inconvenient in business transactions. We, as the Federal Republic of Germany, believe that by using the good faith principle as a common principle of European private law, contracting parties will be protected in a better way. This is because by interpreting the contracts under the principles of good faith and fair dealing, possible gaps and ambiguities left by the parties in the contract may be filled in, and therefore justice is more likely to be rendered in every case. It is important not only to interpret contracts by their literary meaning, but also by the intentions of the parties and the mentioned principles, because sometimes the literary meaning in them may be contradictory and words may be manipulated to reach adverse and unexpected results for the parties. If we do not have the principles of good faith to interpret contracts in the European Union, contracting parties could be affected and justice could be challenged. That is why we suggest the incorporation of the principles stated under paragraph 242 of the Bundesgesetzbuch, or a similar norm ensuring this principle. Thank you very much for your attention.